Hi, I am recording this video in September of 2024. Why is that relevant? Because we're still in the throes of dealing with the ambiguity and other chaos associated with the settlement of the antitrust lawsuit. So this video is intended to address a common question that I'm getting right now. John, I know we're supposed to sign buyers up to a pre-touring agreement, before we take a buyer out on any tours of the property. But what do we do if the buyer won't sign? We can't make them sign. What do we do practically? Do you have any other answer, John, other than don't show them the property, don't take them out on the tour? And as always, I want to build up to the answer. So the first thing I want to talk about is I think this name pre-touring agreement is unfortunate, and I will suggest a better name at the end of this agreement. But this concept of calling it a pre-touring agreement just suggests it's some burden, it's some box that you need to check before you take the buyer out on a tour. And instead, I would encourage you to think of it as a useful tool that all good salespeople use. All good salespeople are trying to qualify their buyers, not in a way a lender qualifies a buyer, but making you all salespeople. It doesn't matter whether you're on the floor of Macy's trying to sell clothes. It doesn't matter whether you're trying to sell shoes in a running store. All salespeople are trying to figure out whether it is worth your time. Whether it is worth your time for you to spend time with this particular buyer. I'll come back to that concept in a minute. Second concept. I would like us to reflect on an experience that we have, I think all of us have had, dealing with medical professionals. I do not know how long this practice has existed, but I think this practice has existed for at least 5-6 years. And that is before we can get service from any medical professional, our doctors, our dentists, our oral surgeons, etc., they all make us sign a form that says something like this: we will do our very best to try and get paid from insurance, but if insurance doesn't cover the whole bill, you are responsible for the difference. This agreement that the settlement agreement calls for is a variation on an agreement like that. And what happens if we don't sign that agreement with our medical professionals? They don't provide us service. In fact, there's a second agreement that I don't know if all of our medical professionals make us sign, but I can tell you my oral surgeon makes me sign this agreement, and I'm pretty sure my dentist makes me sign this agreement. And it's more than just signing an agreement. It's a second agreement that says, John, this procedure that we think you need, that is, by the way, is causing you pain at the moment, we charge this much for that service. We have talked to your insurance company. They will pay that much, and you need to make up the difference, and you need to pay that difference up front. I do it. We all do it. And what those agreements also say is if the insurance reimbursement is less, we'll bill you for the difference. What they also say is if the reimbursement is higher than we expected, we'll send the difference back to you. And as a credit to my medical professionals, I think that's happened twice where the reimbursement has been higher. And in one case, I got a check for $24.31. And in another one, I got a check for $36.12 back. So good for them. That's what fiduciaries are supposed to do. They're not supposed to keep the excess. They're supposed to refund the excess back to the buyer's side broker. All right. Those are tools that our medical professionals use to screen us. Now, let's take that into your context. Real estate brokers, as long as I have been in and around the business, have screened buyers. A natural first question when you're interacting with a buyer is, buyer, are you working with another broker? Are you working with another broker? And you pay attention to that answer. You're looking for a decisive no. If they hedge, you inquire about that, because you know that when somebody has to think about it, they may just be wasting your time and planning on submitting their offer with their brother-in-law, who will charge them a lot less than you will charge them. So you explore that. That's not your only screening question. Another screening question you ask is, are you working with a lender? You're trying to figure out, that's an entree into figuring out whether the buyer has, through a combination of their own funds and the ability to get financing, you're trying to figure out whether it's worthwhile for you to work with these buyers. You're also paying attention to other things about this buyer to make guesses about whether it's worthwhile for you receiving, say, a sign call. Whether it's worthwhile for you to miss your kid's soccer game or something like that to go show a property. All right, so this agreement that you need to have, this agreement that the settlement requires you to have, I think is best thought of as another tool in your toolbox that you must use as part of a screening tool. Now, the form that the Division of Real Estate has created, it's very easy to say this after the fact, and the Division of Real Estate has come up with a form system under tremendous time pressure and tremendous other pressures that is a form system that is much better than I would have come up with working on my own. But after the fact and experimenting with it for a little while now, perhaps it could be improved upon. What the Division of Real Estate has given you as this agreement to get paid, this agreement that you need to have before showing a property to a buyer, is a form that was intended to be a one-pager, but one flaw of the system is they attach that one-pager onto an existing two-page form. To the consumer who doesn't know the history of all that, it feels like a three-page form. Another problem is it's a confusing three-page form. The first page says definitions of working relationships, and that's confusing because there's another standalone form called definitions of working relationships, and then it morphs into disclosure of the relationships when you're working with buyers, and it says this is not an agreement, this is not a contract, but then page 3 is an agreement. And do the limitations of properties on page 1 of that three-pager apply to page 3? So that's one challenge of the Division of Real Estate's current system, is they haven't created this simple one-page tool for you to use to sign buyers up to. Another challenge is there is no additional provisions section in the Real Estate Commission approved form. So if there was an additional provision section, it would allow you to more clearly limit it to one property or the two properties or the three properties that you're going to show this buyer that you hardly know. Because that's what that form is for. If you have history with this buyer, then the goal is to completely bypass this one-pager and sign the buyer up to an exclusive right to buy agreement. The other flaw of not having an additional provision section is, imagine if you're showing your own listing and you know how much the seller is paying you. With an additional provision section, you can make it just like the dentist agreement. I charge this for buyer side services. I charge this for buyer side services, and that's how much my seller is paying me for buyer side services. Therefore, you will owe me nothing. That would qualify, that would comply with the settlement agreement. So, one of the things that I do, one of the things that my law firm does is we create forms that we think that would be useful to the real estate brokerage industry. And how we disseminate those forms is highly regulated. We only disseminate them to our clients. So you have to either be a client or set up an attorney-client relationship with us. But if you are interested in getting the one-pager that we have created, which is essentially the Division of Real Estate's one-pager with an additional provisions section, and also something that eliminates a very broker-oriented sentence in this agreement, even though it's very broker-oriented and the elimination of it makes the form more buyer-oriented. It's having that one sentence in that we've eliminated makes it much harder to explain to buyers. So removing it makes this form quite a bit less scary to explain to buyers. Then we can, of course, provide the form for you. You all know we charge for that. If you're interested in that, send an email. Send an email. She's going to hate me for saying this, but send an email to Andrea at Frascona.com, and she'll take care of you. All right, ladies and gentlemen, so what should we call this? Well, we could call it the dentist office form. That's one candidate name. The other one is, I would say, an agreement for the first date, or maybe an agreement for the first few dates. And you're agreeing to the terms of the first date. And if you filled it out in a way, limiting it to, for example, one property, and indicating that the buyer has no risk because this is how much you charge and this is how much the seller will pay you, so you're not owed anything. If the buyer won't sign it, why the heck would you want to work with that buyer? Ladies and gentlemen, you know my line. We live in a dangerous world. Be careful out there. Catch you in the next one.